Minister. Obviously, I've listened to your response on this, but I still don't think why it wouldn't be sensible to go the extra step and to allow for some kind of verification process. You've indicated how the sending of misinformation to the RTB can be a criminal offence. How the works that are required have to be documented, but there's still no sense of verification. And I know many of us met in the when we had the heads of the bill and in the run-up. In fact, like we've been talking about some of these issues, of course, for decades, but and even since the aftermath of the 2004 Act. But in particular, I'd like to thank Mr. Gavin Elliott and Miss Anne-Marie O'Reilly from Threshold, who met myself and my parliamentary assistant. I think it was back at the end of January. And I know that some of the concerns, they issued a lengthy analysis, I think, of the heads of the bill and then of the bill itself. And I know that a fair number of those were taken on board. But verification didn't seem to be, among them. And I note it's something from a very recent contact with Threshold and other housing advocacy agencies. There seems to be no requirement, they say, on the RTB to verify the substantial works that are carried out. OK, the criminal offence is there, but again, I think the view from people working on the front line certainly is that there should be a requirement, that the RTB verify what's actually been done, and that's what I try to do in Amendment 10. As the Minister knows, I think we were trying to amend Section 19 of the 2004 Act, which was relating to the rent reviews. And of course, we've had lots of discussions about, how we can address the massive loopholes and lacunae in the 2004 Act and in the 2015 Act, and I think there's a clear wish among all tenants and indeed many landlords that we would have these more stringent regulations, and to the extent that you brought them forward, I certainly welcome that. And I know that the Section 5B does create the requirement for landlords to inform the RTB when seeking the exemption from the rent pressure zone restrictions. But again, I think the lacuna here is the lack of verification for the reasons for an exemption, and again we're relying solely then on the landlord's evidence, if you like, and we have to say that in the past that's certainly not, it hasn't been good enough for the people. Again, in this House, of course, we have a very acute knowledge of the sufferings of tenants, and we've come across so many people who have been in outrageous evictions, and where the system has been used to put people on the streets, and week in, week out, we're trying to address that, and it's the reason why we want a much more dynamic, of course, housing construction policy minister. But I think it would, the verification process would supplement the work of the RTB and reduce the likelihood of some landlords applying for exemptions and in fact not carrying out what they intended to carry out. I think the verification is important, because the current crisis has shown us that we know there are rogue landlords out there who take advantage of the massive shortage of supply, of the lack of inspections and enforcement, and of all the loopholes. And I know that's the reason we welcome this bill in general terms, because at least it gives us a platform to try to address that. And the changes you've made there in relation to BEAR, I think, to the BEAR standards are welcome, but again, I think there's some more verifiable system to give that ultimate power to the RTB is necessary, and I'd urge you then to maybe accept the amendment. Amendment 10. the new the 7A, isn't it? Which I think Part 7A, which we all welcome, which obviously does set out a process at long last of invigilation, and certainly has been desperately badly needed. But again, I don't see why you shouldn't meet all of the reasonable requests for improvement of landlord tenancy law that came from the sector, from the advocacy sector. A lot of us met some of the organisations again this morning, Co-op Housing and Oakley and others, when they made a presentation about the improvements they want. For example, the ability for these are approved housing bodies, Minister. They did a presentation for us this morning across the road, and obviously they want a system whereby they will be able to launch their own affordable housing programmes, which is something I think hopefully that you'll be in a position to support. But I think again, I don't see why we shouldn't have the verification there. RTB again, nearly everybody who's here and many of our colleagues, we've dealt with issues that have come out of RTB and the desperate way that long-standing tenants, appalling way that many of them have been treated, even going so far as getting awards, getting compensation for the manner of evictions and so on, and landlords simply disappearing and so on. I know we've addressed some of the outrageous cowboy practices in this bill, but I still think verification is fair enough, and maybe you just go that extra couple of metres and create, make sure that we don't have to come back on this in the future. Thanks, Can. Thanks, Can. I want to move Amendments 16, 17, 18, 19 and 20, and as the Minister knows, they relate to amending the new subsection 2A of Section 66 of the 2004 Act. And that section, of course, provided for the period of notice when Section 67 and 68 of the 2004 Act are not applicable. Section 67 provides, of course, for the period of notice for termination by landlord where tenants in default, and Section 68 provides for a period of notice for termination by tenant where the landlord is in default. And Section 2A, of course, sets out here provisions for notice periods following the adjudication of tribunal and the serving of the remedial notice. But Section 2A, as it stands in the bill before us, would give just 28 days' notice in a remedial notice, meaning that tenants will go through, I think, the whole process of making a complaint about a notice of termination and adjudication or tribunal, and then be issued with a remedial notice, which would just give them 28 days. And again, I notice our housing advocacy bodies, they raise concerns about the shortened time frame on these notices, on a remedial notice, and it would act as a deterrent to tenants who question the validity of notices of termination in the first place. And I think the Minister is familiar with Section 66. Amendment 16, of course, I propose to delete 28 and substitute 19 in Amendment 17. In line 7, I want to delete 28 and substitute 90. And in Amendment 18, I want also to delete 28 and substitute 90 days, and in 19 to delete 28 days and substitute 60. And page 15, of course, to delete line 34 and substitute the following, where it's less than 6 months, that it would be 60 days. Obviously, the legislation before us in subsection 2A, it sets out the circumstances in which the notices will come in. But I mean, as I was saying to you earlier on, Minister, I submitted them because we feel that 28 days' notice is not at all sufficient in the current rental crisis. Nobody could possibly source alternative affordable accommodation in the location they need within 28 days of being given a remedial notice of termination. And I note in the original analysis by Threshold of this bill that they raised very serious concern, and they said, and I quote, "The bill, if enacted, would provide that a tenant who challenged a notice of termination could only have 28 days to vacate their home and find another property, despite the notice having been found to be invalid and the tenant having been vindicated by the RTB adjudicator." And clearly in the current rentals market, of course, again, Threshold makes the point, 28 days is a very short length of time to source another property, and it's especially true for tenants who are in receipt of HAP. And again, that's if you can get HAP in the first place, Minister. The overall effect, I think, that the Threshold and other housing bodies felt of these provisions is that it will discourage tenants from challenging these notices, and it may well lead to an increase in people presenting as homeless, having failed to secure alternative accommodation in the period allowed. I note in the last one there that my colleague Deputy Owen O'Brien, he suggested 90 days for the 28 days in the table, and I can understand the logic behind that suggestions. And I know that the reference, of course, relating to student accommodation and students must be given no less than 28 days. But, of course, the amendments relating to students disapply some of the Act to them, so they won't be covered by everything. For example, Part 4. So it makes sense that some of the provisions not applying to them, given the short-term nature of these tenancies, generally only term time. However, it's people feel that 28 days is a very short amount of time. So I think even 40 or 45 days would have been beneficial, but in the current rental climate, Minister, as I mentioned earlier on, I think that 28 days is simply not sufficient time. Thanks, Ken. The three of them are together, yeah. So just to say that again, in Section 19, of course, is provide the amendment of Section 93 of the 2004 Act, and Amendment 22. Then I propose to delete Section 19 of the bill, and this Amendment 23 is to delete Section 20, which is an amendment of Section 109 of the 2004 Act. So these amendments they relate to the proposed introduction of fees for mediation, Minister, and the introduction of those fees, of course, for the services, we feel, will totally negate the importance of mediation for dealing with residential disputes, and we believe that barriers shouldn't be created in the resolution of the disputes, and that the introduction of charges may do that. And because I think the amendment to Section 93, it removed the restriction on charging fees for mediation, and the only reasonable logic for this is that there is an intention to charge a fee for the mediation in the future. A mediation process, it should be readily accessible, beneficial service to tenants and landlords alike, whose grievance may not require the time and attention of the adjudication process. And the application for any fee for such a process, I think it has the potential to encourage applicants to opt for adjudication, as any failure in the mediation process will ultimately lead to an adjudication or a tribunal. So again, we feel with the annual registration fee for each tenancy, there shouldn't be a financial requirement for the RTB to charge a fee for mediation or to make such a fee in the future. I note if you look at the RTB website, Minister, free mediation is kind of highlighted on it there, and the aim of mediation, it says to give landlords and tenants a shared understanding of the issue so they can work towards reaching a mutually satisfactory outcome and agreement. And it's not, it stresses again the merits of having a free service. So that's 22 and 23, I think, Can. And then I also move 24. It relates, of course, to the reporting of determination orders, and I had a discussion earlier on with the Minister about this, and the reporting we believe should be in an anonymised format, or at least I'd like the Minister to maybe put on the record in relation to that, that the board shall publish in such manner as it thinks fit in an anonymous format. Some of the problems, as the Minister knows, with the rental sector, and of course that wider housing crisis has been, of course, due to the dearth of information, misinformation, or the skewing of statistics and data. And of course, a reliable, transparent and accountable system for reporting on the rental market is vital for a functioning market. And actually, in fact, of course, one way you can look at it, I was reading recently, Minister, about market failure in different parts of the European economy, and I suppose one way you can look at that, our housing situation here has been a total failure of the market in relation to a very significant amount of our citizens. And I think the concern which I'm trying to reflect in that amendment, and I know you don't agree with that, but that the publication of the determination order could potentially be used to blacklist tenants who have exercised their rights as per the Residential Tenancies Act. So there is anecdotal evidence to suggest that tenants they're often afraid to report breakages, needed repairs to their landlords for fear of reminding them, or that they might seem like a nuisance. And there are also reports, of course, of fear around being seen as a troublemaker caretaker by merely asserting their rights as a tenant. So being served with an eviction notice and having to find somewhere else to live, and perhaps without a landlord's reference. So while I do welcome the mandatory reporting of termination orders, I put down this amendment because we felt in general, to protect tenants, that it was important to have the data presented in an anonymised format. Thanks, Ken. Well, I mean, I think this morning one interesting point that the AHBs made in their presentation, the Housing Alliance Minister, was that a lot of the young housing professionals tend to go to work for them rather than for the councils, which is a very interesting point. That you know, in the council it tends to be more like generalists, whereas people who specialised in housing administration or whatever in their education are tending to go to the AHBs. But the other thing about the AHBs is, I mean, some of them are incredibly large now. I mean, it's very striking when you look at an outfit like an organisation like Clúid or like the co-op housing. Like, you could be talking about 4,000, 5,000, 6,000 tenancies, which means, in fact, they're bigger than Fingal County Council, for example, than one of my county councils. They have a huge estate, and the big lacuna, Minister, as you know, in your administration for the last 2 years, that you haven't brought forward that long-promised legislation to encompass and fully regulate the AHBs. We're still waiting on that. I know they were telling us the charities regulator and so on and so forth, but I mean, we're still waiting. We were long promised that in various, I think going back to the time we had Fianna Fáil ministers, we were promised specific AHB legislation, which hasn't happened. But in general terms, I mean, I think all tenancies, should be registered. All organisations providing social housing. So in general terms, I think the thrust of the bill maybe is right in this case. Thanks, Ken.